Hey guys, this is Scott Horn with First Option Title. Just wanted to take a minute and talk about escrow. And this is your earnest money deposit, which oftentimes we call escrow as well. First off, what is the purpose of earnest money? It's really there to help secure the contract. In the legal world, there's three things that you need to have a contract: an offer, an acceptance, and consideration. And the easiest way to have consideration is through earnest money. Now, there can be other forms of consideration that may bind a contract as well, but earnest money is the simplest and the best. Now, why is it there? Well, it's there to help you secure the transaction. It helps the sellers know that if you walk away from this deal for some reason, after the contract has gone hard, meaning no other contingencies, that they have a level of protection to get something back for taking their home off the market for a certain period of time. So it's a way just to help, and work with sellers along the way. Now, when you're entering into a contract, make sure you read your contract. You know what the requirements are for that earnest money, and what your state may or may not require for the deposit of that with your closing agent. But typically you want to be fairly timely in making those dollars paid to the closing agent. Now, oftentimes as an investor, I think it's really important as to what is the amount of the earnest money. I see so many contracts out there that are being offered for cash and various other issues, and even terms where the earnest money is $10 or $100. It's a very, very small, minimal amount. Now, I'm not a fan of that, because if I'm really trying to buy this house, oftentimes I may not be the highest bidder, but if I put a huge foot forward of earnest money where I show that, guys, I'm legit, this deal's going to close, you don't have to worry about it, it may entice the seller to take my offer over a higher priced offer. So that might mean you got to put up a $2,500, a $5,000. Heck, I've put up a $25,000 earnest money deposit, and I won the bid. Now, I know that not everybody can do that all the time, but oftentimes you can. And of course, I do those kind of things with zero contingencies involved. But I also understand that in the traditional retail world, for instance, a buyer who's going to buy a home retail, they're going to have multiple exit strategies on their earnest money. They may wind up having an option period for a home inspection, and during that time frame, they can terminate the contract for whatever reason they wish from an inspection perspective and get their earnest money back without any issues. That's one of the more straightforward scenarios. You also have a financing contingency, which usually requires a special form along with the contract, where the buyer has a certain time frame to obtain their financing. And if they don't get it within that time frame, they have to either cancel the contract, get their earnest money back, or if it goes beyond that time frame, their earnest money becomes non-refundable. And so understanding your time frames in a contract like that are also important, along the way. Is this important, though, as I noted, to stay on top of your time frames? When do I deposit with the title company to make sure I'm timely? What are my dates from an option period or a financing period or other contractual agreements that I entered into as to the that earnest money deposit going hard where it is now no longer refundable? When earnest money becomes non-refundable and a buyer backs out of a deal, a lot of times sellers want the closing agent to just return that earnest money to them. So unless you've got a clause in your contract that directs the closing agent to do things such as that specifically, almost all closing agents are going to want the buyer and seller to agree to the release of their earnest money. Now, that becomes problematic because the buyer doesn't want to sign that and give up their earnest money. And sometimes it does require filing a lawsuit to get that earnest money released back to the seller or the buyer, whatever the case might be. But we want to avoid those lawsuits. So I like to just make suggestions that adding certain clauses to a contract can help navigate earnest money easier and get that earnest money back to either the seller or buyer, whatever the particular scenario may be. Another thing I see out there about earnest money in contracts is when there is an assignment of contract. So maybe an investor has entered into a contract to buy a home, and they in turn have assigned the contract to a back-end buyer who might be a homeowner or another investor. The question becomes, who is now in control of the contract? Because typically once a property is assigned, the assignee, the person who's taking the assignment, becomes the new buyer. And what you've got to think about with this is that earnest money that may have been put up by the assignor or the original buyer is also assigned with the contract to the assignee. So if you're getting a fee up front, you want to make sure that your earnest money is being covered and protected in that regard too. Because once you execute that assignment as an assignor, you are no longer part of the equation. All you have the right to do is to receive a fee either at the time of signing the assignment of contract and or at closing or both. With that, you can put provisions inside of your assignment that gives you the right to retain control of the transaction if the assignee fails to close. Maybe earnest money is delivered to you. But also, you want to make certain that the earnest money, if it's put up by the assignee and not by you as the assignor, where does that money go? Is that part of the transaction between the seller and now the back-end buyer? Or is it something different? You've got to learn to be specific on those scenarios, because if you are not, it creates a problem because the closing agent isn't going to risk releasing the earnest money to one party to the other without everybody signing off on the transaction. The last thing they want to do is get into a lawsuit because they released the money to party A, B, or C along the way and may have possibly done something wrong. So earnest money serves a very direct purpose. It's pretty easy to navigate. There's some time issues and time constraints you need to make sure you are aware of along the way. And make sure you spell out exactly what that money is being used for. And if you want to avoid issues, put some clauses in your contracts that directs a closing agent to do a certain thing with that earnest money based upon what happens in the transaction without having to get everybody's signature involved. So guys, I hope you found this to be helpful. If you did, take a minute and like the video. Don't forget to subscribe to our YouTube channel and make any comments you might have below. We'll see you guys next time.